Welcome to the Money Talk, brought to you by Bartelle's Financial Coaching. I am Theresa Bartelle, financial coach.
And I'm Johnny Bartelle, co-host and spouse.
Today we will be discussing estate planning, brought to you by Charles Weisinger, who's an estate attorney. If you enjoy the content, we ask that you subscribe, like, and share our channel.
Hello, Charles. How are you doing?
I'm doing good. How are you doing, Johnny?
Good. I would like to welcome you to the Money Talk. Could you please introduce yourself?
Yeah, I'm Charlie Weisinger. I'm an estate planning attorney with Weisinger Law Firm here in San Antonio.
Thank you, sir. So, Charles, we know you, like you said, you're an estate attorney. So we want to kind of give the audience on what is an estate attorney.
Okay. So for me, I think when I think of an estate planning attorney, what I do is my job is to help people plan for their future and, really plan for a future that they may not be there for, and saying, making sure that their family is taken care of, kind of think of it as a way to take the burden off of, that burden of worry. I think of myself sometimes as like a professional weightlifter. Somebody comes in with all this weight on their shoulders, just kind of worried and everything. And they come in the office and we put a plan together and they walk out with that weight lifted off their shoulders, and somewhere there. And so we do the things that you would think of when you're thinking of what is estate planning is, we're helping people draft wills. We're helping people work with trusts, powers of attorney, really all of that stuff that just says, if I'm not able to make decisions for myself, or if I'm incapacitated, this is what needs to be done to help with that.
Okay. Now, can you tell the audience how long you have been an estate attorney?
I got licensed in 2008, so I am on my 16th year of practice. Became a board certified estate planning attorney in 2015, so I've been board certified since then.
Okay, all right, that's good.
Nice. So can you tell us a little bit about a will? Can you kind of define that for the audience so they kind of understand what is a will?
Yeah, a will is just simply the document that says, when I die, this is who I want to get my stuff, or what would be considered your probate assets. And I'll define that term a little bit more. Probate is the process of getting assets from one person who has passed away and getting those assets to the person that they're supposed to belong to. The will is kind of the roadmap for probate, but then the probate process, where you actually go to court, is allowed, and the judge approves that will and orders it into probate, is when the assets can actually start to be moved. And so when you say, I'm going to name somebody as my executor of my will, they don't really have any authority in that as the executor until after they've gone through that probate process. But so simply put, a will is just the document that tells the court and tells the public kind of who is supposed to receive your assets after you pass away.
Okay, and can you explain probate just a little bit for people who don't really know what probate is or what that means?
Yeah, I could do that. So talking about here the idea of probating a will, and here when we talk about this, we're talking about probating a will in Texas.
Okay.
Some people own property in Texas and another state, and every state has their own set of rules and their own set of laws. And so when I talk about probate, I'm really talking about what does it look like here in Texas.
Okay.
So if a person passes away with a will and they have property that are on that probate list, those probate assets, so things like your house, cars, personal property, a bank account that doesn't have a beneficiary named, or a joint owner or anything like that. Those are assets that in order for us to transfer the title to those things, we have to file your will with the probate court. And so we actually file an application. Then the court takes 10 days for that to sit there so that anybody can come and complain or challenge it and say, no, that's not the most recent will. He actually left another will here for me. So they have time to challenge that. After that 10-day period, though, if nobody has contested, then we take that will or the court takes that will, and they have the executor comes forward and takes an oath saying, I agree to serve as the executor. I will perform all the duties. And then their job from there is to gather all of the assets, give the court a listing of what those assets are, and then eventually, after giving notice to creditors and making sure any debts are paid, all those things. Eventually, they turn around and take those assets and get them to the beneficiary. So the probate process is really just this whole process of getting assets from the executor in the will to the beneficiary.
Okay.
And also, so the will, we kind of understand that piece of it now. So could you also talk about the trust? Could you tell us a little about the trust and define that?
Yeah, you got to be careful anytime an attorney starts talking about trust. Yeah, just trust me. No, trust really is at its most basic form. A trust is a relationship between a trustee, that's the person who manages the trust, and a beneficiary, the person who benefits from it. And so I really could, I could say, hey, Johnny, I'm going to give you this $100 here, but this $100 is not for you. You're supposed to take this $100 and manage it for Theresa's benefit. Okay?
Got it.
We have just created a trust relationship where I was the grantor. I created the trust. Johnny, you are the trustee in that scenario, and Theresa is the beneficiary. You have a fiduciary duty as the trustee to manage that money for her benefit. Okay? So that's at its most basic sense, is a trust. What we typically are talking about in the estate planning context for most people that we talk about, we're talking about what's called a living revocable trust. And that's a trust that we create while we're living, and revocable means we have the ability to change it or make amendments to it and do things like that. And then the trust relationship is there. So in that scenario, we're typically saying, hey, I want to use this trust as a way to avoid that probate process that we talked about a few minutes. And so think of a husband and wife situation here. So we'll just use the two of you. So Johnny and Theresa, you guys are married. You take your assets and you put them together in this joint trust so that when something happens to one of you, the survivor can keep everything there without having to go through that probate process that we do. Probate in Texas is not a horrible thing. It's a lot better than some other states, but it still takes, 60 to 90 days by the time you go through the process, and it takes it can be, $4,000, $5,000, $6,000 to go through to get, by the time you hire an attorney and go through all of the work to get the probate done. And what a living revocable trust can do is simplify and keep you from having to.
Okay, because that $5,000 to $6,000 surprised me. I thought you were going to say like $500 or $600.
Yeah.
No, unfortunately, probate costs a lot, and that's why several of our clients do go towards the trust, because while it may cost a little bit more in the beginning to do a trust-based plan versus a will-based plan, that avoiding in the future of probate makes a big difference. Because you think about it, if you're talking about, in a situation where there's two of you, we're talking about probating the estate after one of you passes away. So you spend $4,000 there. And then when the second of you passes away, we go through probate again and spend more money.
Wow.
So time and money both times, versus using a revocable trust, we can skip probate in both scenarios.
Okay, and so now when you say probate with that big fat cost, does the executor of the will have to come up with that money beforehand, or is that money taken away from like insurance money that's left, the probate fee?
Yeah, it depends. Most of the time, I mean, if there are non-probate assets out there, like a bank account where the person was named as executor, or has also been named on that bank account, then maybe they've got access to that money there. If they don't, if there's not a non-probate asset, if all that money is locked up in the probate, then a lot of times they're having to come up with the money ahead of time and hoping to be reimbursed after they go through probate. So It's typical. Most attorneys are going to ask for a deposit up front, and so they're not necessarily waiting on you to get access to letters. You have to reimburse yourself later.
Okay, all right.
Makes sense.
Yeah. All right, you want to go ahead?
Yeah. Go ahead.
Okay, so now can you explain to the audience why it is important to have a will or a trust?
Sure, I can do that. We have, unfortunately, as an estate planning and probate attorney, we see both sides a lot. We have clients who have walked in after having lost somebody and realizing how expensive and time consuming it's going to be before they get access to these things. And so let's take somebody who's passed away with minor children in place. if there's children in place, though, if we don't have a plan set out for them, then we're going to take that probate time is going to be just doubled, easily, and the cost is going to be double, triple, quadruple what it costs to go through that sometimes. And then especially if you've got minor children, well, if you've got a 12-year-old child or a 10-year-old child, we can't just hand over the cash, or the property ownership or the money to that child. And so not only are we now having to go through what's called the intestate probate process to make the children be seen as the heirs, but then we're also having to potentially go through a guardianship process before they can, so that somebody can manage those funds for them. And so you see kind of this struggle. I had a client several years ago. She had adopted 2 children, and then she passed away, and both of these children were, minors. She only had about $60,000 in life insurance coming through, and unfortunately, it cost about half of that to get the money to the children, because we went through having to do a full intestate administration for her, and then both of the kids had to go under guardianship, and so the person that she wanted that took over as guardian had to go to court to become guardian, and spending $6,000 to $10,000 per, because each kid had their own attorney by the time the court did it. And so it just became this huge mess, and somebody who already didn't leave much to begin with, and half of it went to court costs and attorney's fees. And that's something that having had a simple will or simple trust in place could have taken what became a $30,000 legal bill would have been at most a $3,000 or $4,000 legal.
Wow.
So having a trust in place or having a will in place makes a big difference there. Okay. And it's not just the will or trust. Having those, typically when we talk about an estate plan, we're talking about durable powers of attorney, medical powers of attorney, some other documents that go along with that, which are all an important part of that thing, because it's not just, unfortunately, it's not just, well, what happens if I die? It's what happens if I become injured. A few years ago, now it's 10 years ago now, my brother was in a major accident and ended up in a comatose state for about 3 months. And unfortunately, he's my older brother, so that means he never listened to anything I said before. Even though I was an estate planning attorney, he didn't have powers of attorney or will or anything. And so when he was in that state, his wife wasn't able to take and cash his paycheck because they were on separate accounts. She wasn't able to deal with get the money out of his bank account to pay the bills or anything without us going to court and having her appointed over him, in that way. And so it can become not having estate planning documents in place can be really detrimental if you don't. And it's simple, but having them in place can make things so much simpler.
Okay, yeah, because I've heard some attorneys and some people say, well, you need to have a certain amount of income before you even consider getting a trust. What are your thoughts on that?
I don't ever use a bright line rule on what the asset value or the value of your house is. I look at every situation as what is it going to take to get the assets you have to the people that you love, and what is our simplest, straightest line to get them there. And so there are people who come in and we say, we can, I have clients coming in asking for a trust, and we walk them through and say, we can accomplish what you need without a trust, and it's going to be this much less expensive if we do it this way than going that way. And so that's my goal, is to figure out the simplest solution possible. And so that could be through the use of things like transfer on death deeds. That can be through the use of wills, community survivorship agreements. There are a lot of different things that we can use, but for a lot of people, the trust is the best way to go.
Okay, and then you just said a term, transfer of deeds. I've heard that term, but yeah, can you explain that? What you just said? What is it?
It's a transfer on death deed.
Okay.
So think about you have a checking or a savings account, and you can name a transfer on death beneficiary for that account, so that it says when I pass away, this person gets all the money in the bank account. Starting in 2017, they created, the legislature created what's called a transfer on death deed for real estate. So I can have a piece of real estate and name you as the beneficiary for that real estate, so that if something happens to me and I pass away, you automatically receive that. I say automatically, there's a couple steps to do it, but you receive that without having to go through probate. And that is an alternative that can be used for some folks if their estate's fairly simple. And there's, I like using the transfer on death deed when there's only one beneficiary, because there's no executor to deal with anything. It's just this piece of real estate is being transferred to this one beneficiary, and they can handle it. The problem that can come with those is if you've got 3 beneficiaries, well, now we just put a house in 3 people's names, and now they're going to have to fight it out to see who sells it or does anything.
Yeah.
You don't have an executor or a trustee with any authority to handle it. So we try to, but they can be, like I said, all of these tools, there's a bunch of great tools in an estate planner's toolbox that is trying to figure out which one is right for each person that we meet with.
Okay.
So I got a question on that. What we was talking about here, the transfer of death deed. Is there a cost once the person passed away and the actual beneficiary gains that piece of property, whatever? Is there a cost to that to do the transfer or anything? So
there's an initial cost, whatever the attorney is going to hire you in drafting that transfer on death deed, and then after the person passes away, you usually have to file what's called an affidavit of death or affidavit of survivorship with the county clerk. And so the attorney will have a charge to draft that and put that together. But it's usually significantly less than the cost would be to go through the probate process.
No probate.
Okay. And then another thing that I want to touch on too, which is a big deal that you educated us on a couple of years ago, is having your home in your trust. Can you explain to our listeners, if they have a home and they decide to go with a trust, what that means if they don't have a trust if one of them dies?
Okay. So the reason the home is often the number one reason we create the trust is because it's your biggest probate asset. And what I mean by that, again, going back to what we talked about earlier, a probate asset, those are things that are naturally controlled either by your will or by the intestacy laws in the state. Okay, so if I own a house, that is a probate asset, unless I put that house into a trust or unless we've done a transfer on death deed or something else there. And so in the scenario, again, if you as a spouse pass away, and then your spouse, in order to get the house fully in their name or then later pass it on to their children, we've got to transfer that title through probating that person's will. Putting it in the trust allows us to skip probating that person's will because it's not a probate asset.
Okay, so that's good. That's okay. So that's what I wanted the audience to understand too. And then, like in a will and a trust, in a will, can you say, okay, I want Bobby to have A, B, C, and D, or does it have to be cut and dry? So, like in a trust, I know it can be pretty direct, but can you also
do that? You can do that in either one. You can have specific bequests in wills. You can have them in trusts. Really, the biggest difference between a will and a trust is just a will has to be probated. Trust does not.
Okay. All right.
At the end of the day, both of them are great tools to get things to your beneficiaries.
Okay.
I like the trust as a tool that helps make it easier on the people that are left behind. Now, I've got clients who say, I don't care. They can pay the cost for probate. They're getting my house. I'm dead. I'm gone. I want to do a will. I'll make it simple, but I want to make it easy, but not too easy. Then if that's where you are, will is a great tool because it'll make it easy, but not too easy. If you want to make it really simple and really cut and dry for your beneficiaries, then a revocable trust is the way to go.
Okay, perfect. Yes. Okay.
So Charles, so I know we talked about the will and the trust. So can you kind of tell the audience what different types of like documents make up a trust? So you can get a kind of understanding of that.
Okay. So a trust typically, it's a trust agreement. It's a document that you guys as, husband and wife, as grantors create this agreement saying we're putting our stuff in this trust. So you've got the actual trust agreement document that's probably somewhere around 20 pages long, but If you've got a complex state, it may be 50 or 60 or 100 pages long.
Wow.
Depending on how complex you want to get. And so you've got the trust document. You typically have deeds for your real estate. So we do a deed from your home to place it in the trust. That's part of funding the trust. That's the biggest problem with a lot of people have seen. If you start Googling about revocable trusts and you hear all of the hate about them, it's because people have created them and never funded them. They never put their bank account in the trust. They never put their house in the trust. And so making sure your attorney right from the start is helping you deed that property into the trust is a big. Then along with that, you'll have documents like an assignment of property to a trust. If you have business interests, we might do some assignments of stock or assignments of LLC, all those things that are there. So every trust, again, it's one of those things. It's not a cookie cutter. Talking about planning for this, you've got to really look at the clients that are in front of you and figure out what do they need specifically for them.
Okay, so like in general, when you put your trust package together, what documents are included with your trust packages?
Well, typically, again, like I said, everybody can be a little bit different, but most people are going to leave our office with the full estate plan that's going to have a durable power of attorney. So that's the document that names somebody to help take care of their finances. They're going to have a medical power of attorney saying this is who I want making my medical decisions for me if I can. We're going to make sure that medical power of attorney has HIPAA language in it, which HIPAA is the Privacy Act that makes all of our health information private. We want to make sure it's released to people. So you have your HIPAA language inside your medical power of attorney and then a separate HIPAA release. You're going to have a declaration of guardian. That's a document that says, if I become incapacitated long-term and I need a court-appointed guardian over me, this is who should be that guardian.
Okay.
You're going to have a directive to physicians, which is also commonly known as a living will, that says if I'm ever in a terminal or irreversible condition, I either want life-sustaining treatment or no, just keep me comfortable. I'm ready to go home. Let me go. So that's your directive to physicians. And then you're going to have a will. And that will is there to talk about who's getting your stuff. Okay. So that's kind of your basic estate plan. If you've decided to go with the trust route, you're going to take all of those documents. And in addition to that, you're going to have the living revocable trust, a document called a certification of trust, an assignment of property to the trust, a deed to get your real estate in there, a memorandum that says this is how it all works. And I'm sure I've left something out,
but that was a good gist.
Yeah,
At least people have an idea of when they put a trust together, what all comes in that trust package, depending on how good your attorney is.
Yes.
Okay. And so now some people, you mentioned bank accounts. Do you recommend that people put beneficiaries on their bank accounts, on their investments? And if they don't, what happens? Yeah.
So again, bank accounts can be, you can name the beneficiaries directly. And if you want them to go directly to a person.
Okay.
If your beneficiary is a minor, you probably don't want the beneficiary to be that minor on the bank accounts. You would rather that account either be owned by your trust or at least have the beneficiary to be your trust. And so when it comes to your regular checking and savings accounts, if you've done a revocable trust with us, we're going to recommend you put those accounts in your trust. We're going to recommend that you take your life insurance policies, your other brokerage accounts. We're going to recommend that you name the trust as the beneficiary or put it in there. Or if you've got, if all of your beneficiaries are grown and they're able to, they're in good financial shape, you could just name them directly on the beneficiary form with that life insurance form. So everybody's a little bit different. What we don't want to have ever is that brokerage account out there or bank account that has no beneficiary named, and because then that ends up becoming a probate asset, and so we end up going back through probate. So the biggest deal there is, whether you're going to put it in the trust or not, you want beneficiaries named or you want it in the trust.
Okay. All right. So now we know if you have an account, a bank account or an investment account, if you do not put a beneficiary on it or have it in your trust, then probate gets to decide what happens. Correct?
Correct.
Okay. All right.
Well, What do you recommend for people who got remarried with children?
Don't. Listen,
That was a good one.
from an estate planning perspective, it's a mess sometimes. Don't. Yeah, I think the biggest thing really be when you're thinking about remarriage, or if you've got that blended family that's you're trying to figure out what to do. The biggest thing really is for the two of you to to open lines of communication and be honest with what's there, and you figure out real quick, are we joining all of our assets together, or are we leaving some separate? What are we doing? But there's no, unfortunately, there's no magic answer in this scenario. You've got some blended families, you blend, and 40 years later, they're still not blended. They're still very much separate. And some blend really well, and you leave everything there. I think it's just kind of being open. With minor children, it's a big deal. I think you're, if you've got kids that are minors and that are still reliant on you, then I think you've got a responsibility to make sure that you're leaving something directly to them, not just leaving it to your spouse and trusting they're going to take care of, whether that's doing it through some life insurance funding or something else there, having that, that's the easiest way to make sure that your kids are taken care of, is to just go get a life insurance. You can leave everything to your spouse if you want to and trust that they're going to take care of most of it, but take a life insurance policy, set it aside and say, this goes to my kids, and that way if something happens to you, they're taken care of. We don't have to do it, because it's, unfortunately, in the blended family issues, that they don't, I see too often where one spouse passes away and then the family just gets fractured, and there's not, everybody got along well while they were together, but not so much anymore, or that future remarriage happens because the casserole lady starts showing up,
And guess what? She will definitely show up too. So you have experience. You've seen this happen to blended families. I'm like, just hearing you talk about how you can't really trust your spouse to take care of your child after you're gone, it made my chest tight. Yeah. So you've seen this before.
Oh yeah, I've had clients that sit in my office together and they make a plan, and they say, I'm gonna, and they look at each other and they say, oh, well, I trust him. He's going to take good care of, he'll take good care of my kids, or she'll take good care of my kids. And then fast forward 2 years, he passes away, and she didn't like the way the kids talked to her at the funeral. They were asking for money too soon, or they were asking for, or they didn't do something right. And now and so she's back in our office saying, what can I do to change my trust? And it's her right to do that. She can change them at that point. And so we like to help, I counsel every family. I don't care how happily married they are and how long they've been married. I counsel them on, this could happen. This is something. So what are you doing to make sure that your kids are provided for? It's a tough situation though, because a lot of people don't have the ability to set something aside. Otherwise, they're we live in a society where we're paycheck to paycheck.
Amen.
And so you've got to take care of the person next to you, but you've got to balance that with taking care of kids that can't take care of themselves too.
Oh, Charles, that was so powerful. I didn't even think about the casserole lady. I
got that from one of my clients who was a pastor, and he was talking, and he said,
you know what? It's funny, but the sad thing is, it's true.
It is, yeah.
Yeah, before you get embalmed, she'll probably be bringing casserole and lobster too.
Yeah.
That's true. Okay, so now that we got all of our documents in place, how often should they be updated?
I think, how often, I would tell you, I like to put my documents and tell people to put your documents on a bookshelf where you'll see them every now and then, so that if some major life changes happen, it triggers you to think about it, and then the other time to do it, look at them yourself every year at tax time. You're already miserable. You've been dealing with taxes all day. Just finish out the day by looking at your estate plan. We'll put death and taxes together. Right? And so look at it and think, okay, did anything major happen in last year? Anybody get married? Anybody die? Anybody, did we sell property? Did we do anything? Is there a reason to call my attorney and check up on this? And if the answer is no, put it back on the shelf and go have your celebration that it's all done and deal with it next year. But if there's something there that you see, then call. If you go through that for 5 years, then I would say every 5th year or so, call your attorney. And at least at a minimum, you're going to redo your powers of attorney. You're going to get, even if you're not changing people, you're going to refresh those so that we keep those fresh for doctors and banks and things.
That sounds good.
All right. So you have been giving some great advice, Charles. So is there any other advice that you have that you would like to provide to the audience that you think that they would need to know?
I think overall, it's just, estate planning is not something that most people enjoy talking about. I learned that very early on after when my wife and I were having our first and second child. It took me twice to learn it, because when she told me she was pregnant, the first thing I thought was, we need to update our estate plan. And she said, her response to me was, well, can we talk about being pregnant for a couple of days and just be happy with that before you talk about my death? And I thought, okay, I get it. So we don't, so it's not something that most people enjoy talking about as much as I do, but it is something that's important to get done. It's important to do this, and it's important to do it right. We see people that try to do it themselves and not go to an attorney, not have a professional do it. And unfortunately, a lot of times we see the aftermath of that, and it's broken, and it's challenging, whether, it's the property's not going to the person that they wanted it to, or it's just taking a whole lot more time and money than it was. So take care of yourself, take care of your family, and get it done sooner rather than later. Don't put it off.
Okay. And so now with your practice, are you only practicing in Texas? Because you never know, some of our audience members might want to call you. But are you only?
Yeah, we are only licensed here in Texas.
Okay.
But so we, if you're listening to this and you're wanting information for somebody outside of Texas, you can call us. We can try to help you give you good information on who you can talk to. But we're only licensed here in Texas.
Okay. Well, that's good information too. Yes. Thank you so much, Charles.
Well, we would like to thank you for sharing your time with us to this evening on the Money Talk. And we really appreciate all of your great advice that you have provided to the audience. I think this is going to be critical and make people think about what they should do next, whether they should get a will or a trust or whatever they may do. But if they don't even have a will or trust, this will actually hopefully engage them to really think about it and consider it. So thank you very much for your time.
Johnny and Theresa, it was good to see you guys again, and I appreciate you having me on.
Yes.
You're welcome. So enjoy your afternoon, and we'll be seeing you soon, I'm sure.
Yes.
All righty. Thanks, Charles.
Right, thank you.
Thank you.
All righty. Bye-bye. Audience, now you have to admit that interview was amazing. If you do not have a will, I highly recommend that you get one, because if you love your loved ones while you're here, you need to love them when you're not here. And one thing that I know for sure is we all have a date and time that we're going to leave this earth. So if you have family that you love or children that you love, take care of them now while you're here and invest in a will or trust.
Yes, and I would totally agree with that, because you just don't know the date or the time, because like my wife said, and like the Word of God says, we're all appointed once to die, then after that the judgment. So if you're looking at this video, the show, please consider, if you don't already have one in order, think about your family. If you are no longer here, how would you want them to go about living after you are not here? Because you don't want them fussing or fighting, and you're not here because there's no will or no trust available for them to understand what your wishes were, because you're no longer here. So this was very powerful.
It is. And so again, this is the Money Talk, and we talk about money. And so we're talking about your money for you while you're here, and we're talking about your money for you after you're gone. Please don't allow your family to be in a feud over assets. So take care of your family now while you're alive. And again, if you enjoyed the content, we ask that you subscribe to our show. We'll be here every single Thursday, and you can subscribe, you can share it, and you can like it. So again, go out, find yourself an attorney. Our attorney is here in Texas. We'll put his information in the show notes. And if you need advice in Texas, he'll be able to help you. And if you need an attorney outside of Texas, you can call his office, and that they will also be able to help you there. So again, thank you so much for watching the Money Talk, and we'll see you here again next Thursday. Bye.
Bye-bye.